is a judgment of the single judge. I'll cite the single judge decision, and this has been affirmed by the division bench. It starts at, my lord, page 24. And the issue was here, my lord, that the petitioner was a candidate appearing for the CBSE, my lord, the medical entrance test, and she wanted to wear a headscarf, which was not permitted. And lordships will see the question which arose at page 24. The prescription of dress code for All India Medical Entrance Test 2016 is questioned in this writ petition. The first petitioner is a candidate appearing for the entrance test. Second petitioner is the father. Then, my lord, paragraph 4. In a country like India, a predominantly religious society, the court will have to examine the religious freedom in the light of the constitutional scheme, what your lordships also put to me. The religious freedom to profess, practice and propagate is a fundamental right subject to public order, morality and health as provided in 25(1). There are occasions in matters of public affairs or related secular activities leading to instances of conflict between religious practices and state interest. Exactly, my lord, the issue here. Essentially, this conflict veers around religious practices rather to freedom of conscience. The courts are often called upon to decide the question of conflict between the right of religious freedom and the state's duty to regulate public affairs in matters of general nature or secular activity. That is 25(2). Therefore, the individual's religious rights, when entangled in public law, have to be resolved by the court by assimilating individual rights and state interest. Then, my lords, Bommai is cited, which is, my lord, it's a secular republic. Then, my lords, I will not trouble your lordships with all the other citations. Then, my lord, kindly turn to para 28. Page 28, well, I'm sorry, page 28, para 13.
I'm sorry to interrupt my learned friend, my lord. If he can share a copy of the index, my lord, it will be...
Yes, we'll just do that. I'll request, if you can, sir, give me your mobile number, I'll just ask them to WhatsApp the entire...
You can just send it by email to instructor.
Yes. Shahul, just organize this, please.
Thank you.
Page 28, para 13. In dealing with the question of freedom of religious practices, the court must dwell on to find such practices are essential to maintain the identity of a person to profess his faith in the religion he practices, and if not allowed, whether it would result in the wrath of injunctions of the religious doctrine he professes. One of the salient features of the religious tenets is the moral obligation that one has to carry in formulating his conduct in obedience to the command of superior power, in manner his conduct to be conducive to become more obedient to the legal obligation or legal duty under the temporal law. This moral obligation cannot be allowed to be interpolated by outside ethos. If the religious tenets do not allow a woman to become a priest, the state cannot import secular ethos of gender equality to allow a woman to be appointed as a priest. So this is, my lord, the broad contours of the essential religious practice test. And then, my lord, the court then goes on to, my lord, the core issue, which is, my lord, page 29 in that case, about the dress code. Coming back to the core issue in the writ petition about the dress code, it is to be noted that Islam embraces and encompasses the guidance to the humans in all walks of life. Shariat is Islamic law. Sharia contains of two things: law revealed through the Quran. Number two, the laws that are taken from the lifestyle and the teachings of the Prophet Muhammad. This part is called hadith. And even in mullahs, lordships have seen Muslim law, this is the primary source of Islamic law. The Holy Quran consists of a broad and general prepositions. It is often, though hadith Quranic prepositions are interpreted or explained. Therefore, the validity of expected conduct of the believer rests on the credibility of reporting of hadiths as well. The whole idea of Quranic injunctions and hadiths is to reduce the rights and obligations to formulate certain standards of behavior of individuals in his conduct in obedience to the commands of God. This presuppose to bind his own behavior as well as the community. Then, my lord, kindly turn to the relevant verses as far as this headscarf is concerned, which is at page 30. Para 20. Para 19, I'll read. The petitioner's concern is that the dress code as now prescribed would not allow the candidates to wear the headscarf and full sleeve dress. It is the case of the petitioner that the Sharia mandates women to wear the headscarf and full sleeve dress, and therefore any prescription contrary is repugnant to protection of the religious freedom as provided under Article 25. Therefore, this court has to examine the nature of dress code prescribed for women in Islam, and such practice is an essential part of religion or not, and if it forms part of essential practice, can it be regulated in the light of Article 25(1). So this is the core question, my lord, which fell in that court, which fell for consideration, my lord. And they cite, my lord, in chapter 24, verse 31, which reads, my lord, and tell the believing women to lower their gaze and to be modest and to display of their adornment only that which is apparent, and to draw their veils over their bosoms and not to reveal their adornment save to their own husbands or fathers or husbands' fathers or their sons or their husbands' sons or their brothers or their brothers' sons or sisters' sons or their women or their slaves or male attendants who lack vigor or children who know not of women's so and so, and let them not stamp their feet so as to reveal what they hide of their adornment. So, my lord, a specific, my lord, injunction in verse 31, which is based on, my lord, that modesty has to be protected, that they have to draw their veils over their bosoms. And then, my lord, para 22, in the original text, my lord, they say that the veil is referred as khumur, and khumur or head cover is the cloth which covers all the hair on the head, while the word juyub means not only the bosom as commonly thought, but it includes the neck too. Then, my lords, paragraph 24.
What is khumur?
My lords, khumur, my lord, that is what they have explained, my lord, is a head cover. Head cover in Arabic, that is the cloth which covers all the hair on the head. Now, that is probably a headscarf. Your lordships are right, my lord. That's
khumur belongs to hijab.
Yes, my lord. I'm grateful, my lord. I'm grateful, my lord. Lords, over the page, page 31, my lord. Lords, over the page, para 20, para 23, my lords, verse 59 is quoted, which also, my lord, is in the similar vein. And para 24, my lord. Lord, just to on the side, Lord, I am citing all these verses. Lord, it is being, lordships are absolutely right, my lord, that people should not report all this in the media. Because, my lord, there is a controversy that I, as a Hindu, my lord, I am citing this. I am only doing my duty, my lord, as to assist your lordships, my lord.
You are a lawyer first.
Yes, my lord. That's right, my lord. That's
lawyer
right.
First.
That's why, my lord, what your lordship said right in the beginning, that the media should be more responsible, my lord, I absolutely agree. I couldn't concur more, my lord. My lord, so now all this is analyzed, and para, my lord, 29, page 32, over the page, my lord. Thus, the analysis of Quranic injunctions and hadiths would show that it is farz. I'm sorry, my lord, the Chief Justice got it? No?
Yes.
Yes. Thus, the analysis of the Quranic injunctions and hadiths would show.
Yes.
Show that it is a farz to cover the head and wear the long sleeve dress except face part and exposing the body otherwise is forbidden haram. When farz is violated by an action opposite to farz, that action becomes forbidden. However, there's a possibility of having different views or opinions for the believers of Islam based on independent reasoning. The court is not discarding such views. The possibility of having different propositions is not a ground to deny the freedom if such propositions have some foundation in the claim. As has been adverted above, the claim of the petitioner is well founded. Even though a different view is possible, this court is only expected to safeguard such freedom based on the Constitution in preference to giving a religious verdict. Lord, I just pause here for a minute. Lord, what the court is saying is very, weighty, and this is also fallen for consideration in that Vijay Emmanuel's case, my Lord. If, my Lord, there is a practice which the believer thinks, my Lord, is a part of his faith, and that practice by itself is innocuous, it is not something, my Lord, which by itself violates public order. By itself, my Lord, it does not infringe anybody else's freedom. So therefore, my Lord, in that context, actually, my Lord, the test of essential religious practice will not actually arise, because this is simply a facet of an innocent. Yes.
Is it your case that these students,
yes, my Lord,
who are insisting for wearing this headdress, they had been practicing this for considerable time?
I am absolutely grateful for this question, my Lord. As far as the petitioners in this case, it's a pleaded case, my Lord, that right from their admission in this PU college, we had been going there, my Lord, with a headscarf, and we were wearing a headscarf, my Lord, of the same, Lord, there is no difficulty, of the same uniform, till this GO came, my Lord, and said headscarf is not
since when they were going on this?
For last 2 years, my Lord, I've said that in my writ petition. No, these are second year PU students. I've said that in my writ petition, my Lord. I'll draw the Lordship's attention to the paragraph numbers also, but kindly make a note that it is my case that we have been wearing a headscarf. There was absolutely no trouble.
Since admission, you had been wearing it.
Yes, my Lord. I'm grateful for that question, my Lord. So that will, my Lord, probably put things into perspective. And this is not a case, my Lord, where the students are insisting for a different uniform, that I will wear something else other than the prescribed uniform. They are only saying, my Lord, that they will only cover their head, and not only with not with a different color, with the same color as the uniform which is prescribed. And according to me, my Lord, this is an innocuous practice, and considering the, my Lord, broad width of fundamental freedoms enshrined in the Constitution, the state should facilitate that exercise of that freedom, my Lord. That's the submission. Then, my Lord, page 32, paragraph 30, I'll just finish this, my Lord. The discussions above, as would show that covering the head and wearing a long sleeve dress by women have been treated as an essential part of Islamic religion. It follows a fortiori that Article 25 protects such prescription of the dress code. And Vijay Emmanuel is quoted, my Lord, which Mr. Hegde also cited that day. And then, my Lord, para 32, also the same thing, the right of women to have a choice of dress based on religious injunction is a fundamental right under Article 25(1). When such prescription of dress is an essential part of religion, as has been noted above, the right can be negated only in the circumstances mentioned in 25(1). And ultimately, my Lord, they were permitted to, my Lord, wear that headscarf in the medical entrance test. Now, my Lord, this came up before the division bench, and the division bench, my Lord, judgment is the next judgment, which is page 35. The CBSE challenged this, my Lord. And during the pendency, my Lord, of this writ appeal, the government, the CBSE came out with a notification, my Lord, where, my Lord, certain measures were put in place. And one of the measures was that if you are wearing a religious dress like a headscarf, etc., you should come in half an hour or 1 hour earlier so that security, etc., can be looked at. Those girls can be properly checked before they enter the examination hall. And that is, your lordships will find at page 37. The judgment starts at page 35. The subsequent notification which came during the pendency of that writ appeal is noted at page 37. And the court notes it in paragraph 5. A copy of the notification issued by the CBSE was also made available to the learned counsel appearing for the writ petitioners and the learned Assistant Solicitor General of India appearing for the Union of India. It is evident from the notification dated 26th April 2016 that the candidates coming in customary religious dress are permitted to appear, subject to the rider that they report to the center by 8:30 a.m. for proper frisk-screen. Nobody can have any objection, my lord. If you are insisting on wearing something which the state feels needs more security check, etc., those kind of restrictions can definitely be put in. With those observations, my lord, this writ appeal was disposed of. My lords, while I am at this juncture, my lord, I also want to point out one thing. In fact, my lord, the Kendriya Vidyalayas, my lord, sir, when I am on this law, I just want to complete this. We have filed a memo, my lord. The Kendriya Vidyalayas, even today, they permit, my lord, by a notification that even though they have a uniform, as far as Muslim girls are concerned, my lord, they are permitted to wear a scarf matching with the bottom wear with the red hem on the corners. But that memo we have just filed, my lord, just if your lordships can just have a look at that. Not just to, my lord, because even at the national level, my lord, this has been the tradition, my lord, that governments have permitted headscarves to be worn even in Kendriya Vidyalaya. Just have a look at, my lord, page, my lord, this is the uniform which is prescribed. Just have a look at page 3, my lord, of that. Now, I'm not saying this will actually, my lord, bind the case either which way, but just a relevant consideration, I thought, my lord. Page 3, if your lordship sees, scarf for Muslim girls, gray color scarf matching with the bottom wear with red hem on the corners. And see also, my lord, as far as Sikhs are concerned, also that headgear allowance is there, my lord. So this is in line with Article 25, my lord. Yeah. Now, my lords, the next judgment which I wanted to cite is another DB judgment, which is in this compilation, my lord, at page 13. Justice A.P. Shah, my lord, and Justice Chandru. And here, my lord, the question which arose was that the Election Commission, my lord, had asked everyone, my lord, to give their photographs for the purposes of electoral rolls. And that was challenged, saying that, look here, directing women from Islamic faith to actually have their photographs printed on electoral rolls, etc., would be violative of Article 25. That was the challenge, my lord, which was made, which your lordships will find in paragraph 2, page 15. If I can just place that, my lord. Paragraph 2. The constitutional validity of the aforesaid direction is put in issue in this writ petition under Article 226. The petitioner Ajmal Khan is seeking for issuance of writ of mandamus, forbearing Election Commission from any way publishing or releasing the photographs of women, particularly the Muslim Gosha women in the eligible voters list in respect of all constituencies in the state of Tamil Nadu. And then they say this is violative of their fundamental rights. And my lord, the court notes all the sources of Islamic law, etc. And if I can just place, my lord, paragraph 15, page 20. And the court says, my lord, wearing a parda is not essential, but headscarf is. Just see, my lord, paragraph 15, page 20. All the different Canadian writers, judgments of various different jurisdictions are noted. Para 15, my lord, bottom of that page. In 1992, Justice Yusuf of Malaysian High Court delivered a judgment ruling that freedom of religion guaranteed under Article 11(1) of the Malaysian Constitution was not absolute. The prohibition against wearing attire that covered the face did not affect the appellant's constitutional right to profess and practice her religion. This decision of the Malaysian court was confirmed by the Malaysian Supreme Court. It is thus seen, the last three lines, my lord, it is thus seen from the reported material that there is almost unanimity amongst Muslim scholars that parda is not essential, but covering of head by scarf is obligatory. This is what I am commending for my lord's kind consideration. That headscarf is obligatory, covering by parda, etc., is not essential. So, my lord, two division.
Malaysia is a secular country or theistic country?
My lord, definitely, my lord. It's a theistic country, my lord. I bow down, my lord.
Islamic country.
Yes, my lord. Islamic country, my lord. Lord, our principles, my lord, definitely are much more broader, my lord. Lordships are aware. We cannot actually compare ourselves with any Islamic constitution. But what I'm only submitting is this, my lord, that authorities on Islamic law seem to suggest that as far as wearing of headscarf is concerned, it is an integral part of their faith. That is all I was, my lord, making a submission. Now, my lords, two high courts have taken a view. Kerala High Court Division Bench, Madras High Court Division Bench, that wearing a headscarf, my lord, is obligatory as far as Islam is concerned. Now I come to those three judgments, my lord, which have been cited in the GO and which the Honorable Chief Justice put to me. The first judgment, my lord, which the GO cites, is a judgment again of the Kerala High Court, which your lordships will find in item 6, which is at page 39. Also note one interesting thing, my lord. This judgment is authored by the same learned judge, my lord, Justice Mushtaq, who also authored, my lord, that earlier judgment which I cited, upholding wearing of, my lord, headscarf as an essential part of Article 25, my lord, when it came to the question of those girls, my lord, in a CBSE setting. Now, my lords, this case, my lord, the learned judge was faced with a situation where, my lord, a minority institution, my lord, came. The question was whether a Muslim girl can enforce this right qua a Christian minority institution. Please see page 39, respondent number 4 and 5. This was, my lord, the principal Christ Nagar Senior Secondary School. And please see 5, manager Christ Senior Secondary School. So the context, the text and the context of the judgment is primarily dealing with the rights of a minority educational institution vis-a-vis Article 25 right. And the court says a minority educational institution's right to administer institutions of their choice or admit students is paramount. It will override Article 25 right. So just have a look at, my lord, page 39. Religious dress in a private educational institution is an issue in this writ petition. So the state can't rely upon it, my lord. Today, the GO doesn't apply to minority institutions. The GO applies to government institutions. So therefore, my lord, my submission is that reliance upon...
private.
Yes, my lord. Then, my lords, may kindly see... I'm sorry, my lord.
The issue is not the minority institution, private educational institution.
No, it's private educational institution, which is a minority, my lord, because the court notes this. And I'm grateful for that question. Just have a look at, my lord, first para 3, my lord. a private educational institution doesn't have a higher right, my lord, than a normal institution. It's only a minority institution which has a right under Article 30, which your lordships are aware. One has the liberty to follow his own notions and convictions in the matter of dress code. At the same time, when such a right is claimed against a private entity, which is also having equal fundamental right to manage and administer an institution, that your lordships are aware, my lord, of Article 30. If I can just place Article 30. Lordships will see Article 30, my lord. I'll not, lordships will just have a look at Article 30. All minorities, whether based on religion or language, shall have the right to establish and administer educational institutions of their choice. So this was a Christian minority institution. And then, my lords, in paragraph 4, that earlier judgment is noted. And then, my lord, see what the court says. The right, paragraph 5. The right to establish, manage, and administer an institution is equally a fundamental right. Fundamental right is traceable to Article 19, of course, subject to reasonable restrictions. TMA Pi, PA Inamdar, all these judgments are cited. And ultimately, in paragraph 10, the court says, page 41, in such view of the matter, I am of the considered view that petitioners cannot seek imposition of their individual right.
Yes.
Yes, my lord. Para 41, page 41, my lord. In such view of the matter, I am of the considered view that the petitioners cannot seek imposition of their individual right as against the larger right of the institution. It is for the institution to decide whether the petitioner can be permitted to attend the classes with the headscarf or not. Correctly, absolutely correct, my lord, constitutionally. Minority educational institutions can't be, my lord, foisted with, my lord, students whom it doesn't want to admit, number one. And, my lord, as far as headscarves, etc., these are matters which will be prescribed by, the standards will be prescribed by that institution itself. That freedom is there under Article 30. The next judgment, my lord, which the Geo cites, is a Bombay High Court judgment.
Mr. Kamath.
I'm sorry, my lord.
Sorry for the interruption.
Yes, my lord.
Retrace your steps.
You should not be sorry, my lord. It's
Steps.
an opportunity to understand.
Yes, very well.
Yes.
You quoted the High Court judgment,
yes,
which had referred to the decision of the apex court of an Islamic country,
yes,
which held wearing hijab is an essential religious practice of Islam. Do you have any other courts of any other Islamic countries, apart from other secular countries, where they have taken a divergent view on this?
My lords, as far as my research so far goes, my lord, I have not been able to find out, my lord, any authoritative verdict which has taken a contrary view as of now, my lord. But I stand corrected. Lords, I am not the sole repository of all knowledge. My lord, as of now, my research shows, my lord, that as far as this headscarf is concerned, there is no authoritative pronouncement by any court saying that it is not a part of essential practice of Islam. As of now, I can say that. Now, my lord, the second judgment, which the Geo cites, is AIR 2003 Bombay 75, which is the first judgment, my lord, in the compilation. And this again, my lord, I respectfully submit, doesn't actually help the state government, because this was rendered in the context of an all girls section. And therefore, my lord, the injuncts which are there in the Islamic faith, that you shall not show your head, etc., to a member of the opposite sex, those will not be violated in an all girls section. And that probably, my lord, weighed with the honorable court, which I want to show at page 2. Para 7, my lord. A girl student not wearing the headscarf or head covering studying in exclusive girls section cannot be said to in any manner acting inconsistent with verse 31. It is not an obligatory overtake enjoined by Muslim religion that a girl studying in all girls section must wear head covering. My lords, I need not cite authorities on this, but your lordship's court have time and again said that judgments cannot be read as Euclid's theorems, my lord. It has to be seen in the text, it has to be seen in the context, my lord, of the facts which were there before the court. And both these judgments which the GO cites, one minority educational institution, one all girls section, doesn't apply, my lord, in our case. And the third judgment, my lord, which the GO cites, is a Madras High Court judgment, which your lordships will find, my lord, at page 4. This has nothing to do with Article 25. I'm quite surprised, my lord, that the state chose to rely upon this judgment. This judgment, my lord, I will not trouble your lordships, but lordships may make a note. This judgment, there is not even one word on Article 25. There is not even one word on headscarf. This was a case where the government prescribed uniforms for teachers. And under that educational act, whether that was permissible or not, whether under the contract with the teachers, the government could enforce a uniform, that was the issue. Nothing to do with Article 25. And the GO says, with respect, that these three decisions show that Article 25 says that headscarf is not covered under Article 25. I respectfully submit, my lord, this is a fatal error. Number one. Now, my lords, with this, lords, I go to my first, my lord, Supreme Court judgment, which your lordships will find, because the GO says we have considered Supreme Court judgments, High Court judgment. There are no Supreme Court judgments in any of this. Now, the Supreme Court judgments which are actually applicable are these. First, lordships will turn to the Shirur Mutt case, which your lordships will find at page 42. Lordships are aware, my lord, the facts of this case. A scheme was sought to be, my lord, imposed, and the Mathadipati objected. And in that context, my lord, kindly see page 50, where I'm saying that a dress prescription can also be a part of Article 25. Just have a look at, my lords, page 50. It starts at page 42. Page 50, about paragraph 17, my lord. I'll not trouble your lordship with the entire paragraph. The last about 4 lines of paragraph 17. It starts with, there are well-known religions in India. My lord, the Chief Justice got it?
Yes, yes.
Yes. There are well-known religions in India, like Buddhism and Jainism, which do not believe in God or in any intelligent first cause. A religion undoubtedly has its basis in a system of beliefs or doctrines, which are regarded by those who profess the religion as conducive to their spiritual well-being. But it would not be correct to say that religion is nothing else but a doctrine of belief. A religion may not only lay down a code of ethical rules for its followers to accept, it might prescribe rituals and observances, ceremonies and modes of worship, which are regarded as integral parts of religion, and these forms and observances might extend even to matters of food and dress. This is what, my lords, I wanted to place for my lord's consideration. So the dress, my lord, is also a part of a religious practice, and this is not what I say, my lord. This is what the Supreme Court settled way back in 1954. The next judgment, my lord, which I want to cite is Ratilal Gandhi. Page 67. It starts at page 63. And this was again a case of a my lord, Jain Trust, and whether, my lords, certain sections of the Bombay Public Trust Act, which took away the certain powers of those trusts, my lord, were legal or not, and certain sections were struck down, say that it was contrary to Jain religion. And in that context, my lord, just have a look at just one page, my lord. Page 68. No outside, sorry, my lord, top of that page, my lord. Page 68. Page 68. No outside authority has any right to say that these are not essential part of religion, and it is not open to the secular authority of the state to restrict or prohibit them in any manner they like, under the guise of administering the trust estate. Lord, the proposition which I am canvassing is this: the state is an outside authority. It cannot give an authoritative pronouncement on whether wearing a headscarf is an essential part of religion or not. It has to be looked at, my lord, from the point of view of the believer, of that person who professes that faith. Lords, my lords, as a citizen, as a counsel, as an officer of your lordship's court, I may not agree with the headscarf at all. I may personally think it is very regressive. I would think, my lord, that everybody should have a same uniform, but it is not for me, my lords, and for that matter for your lordships also. Because that is what the Supreme Court says in B.J. Emmanuel, that it is not for the court to sit in judgment. It is to be looked at, my lord, from the point of view of the believer. And that is why, my lord, that B.J. Emmanuel's Justice Chinnappa Reddy's judgment is written so beautifully, my lord, which encapsulates our secular ethos. Just have that judgment, my lord, page 75. Starts at page 75. And if we just replace, my lord, the facts of this case, that is wearing a headscarf innocuously, not disturbing anybody, going to school or a college, just have the same facts, my lord, transpose it to this case, and kindly see how this case fits on all four. And I respectfully submit, there is nothing else to be seen, my lord, in this case is concerned. This is totally covered by B.J. Emmanuel on all counts. Just have a look at the judgment, my lord. Starts at page 75. Page 79, my lord. The facts. As a citizen, my lord, I will not agree. Why should a student not chant or sing the national anthem? But the court said it's their right. They are not creating a hindrance to anybody. The Constitution has permitted them. Just have a look at that page 79, my lord. 3 child applicants, Bijo, Mino Mall, and Bindu Emmanuel, are faithful of Jehovah's Witnesses. They attend school daily during morning assembly. When national anthem Jana Gana Mana is sung, they stand respectfully. I'm sorry, my lord, the Chief Justice got.
Yes.
Yes, ma'am. When national anthem Jana Gana Mana is sung, they stand respectfully, but they do not sing. They do not sing because according to them, it is against the tenets of the religious faith, not the words or the thoughts of the anthem, but the singing of it. This day and before them, their elder sisters who attended the school earlier have done all these years. This is very important because that's the question which the Honorable Chief Justice asked me, whether they have been doing this all these years. And I say yes, in the writ petition paragraph 6. But now continuing, my lords, no one bothered. Just see this, my lord. No one bothered. No one was worried. No one thought it disrespectful or unpatriotic. The children were left in peace and to their beliefs. That was until July 1985, some patriotic gentleman took notice, in this case the state, on 5th of February. The gentleman thought it was unpatriotic of the children not to sing the national anthem. He happened to be a member of the Legislative Assembly. So he put a question in the assembly. A commission was appointed to inquire and report. We do not have the report of the commission. We are told so and so, my lord. Then, my lord, they were expelled from school. And then paragraph 3, they went to court. Paragraph 3, my lord. that the petitioners truly and conscientiously believe what they say is not in doubt. They do not hold their beliefs idly, and their conduct is not the outcome of any perversity. Just see, my lords, how beautifully it is put. They do not hold their beliefs idly, and their conduct is not the outcome of any perversity. The petitioners have not asserted these beliefs for the first time out of any unpatriotic sentiment. Jehovah's Witness, as they call themselves, appear to have always expressed and stood up for such beliefs all the world over, as we shall presently show. Lord, it is not a case where somebody comes up with a shawl and says that, look here, that I am asserting my right. This is a case, my lord, where the students have been wearing their headscarf for years together. And then, my lords, may kindly see how the court deals with this. First, my lord, the court says in paragraph 14 that the circulars which the state relies upon, that can't be the basis of restricting this freedom under Article 19(1)(a). And that's going to be my second limb of submissions, but just make a note of this at page 84. The argument which I am going to make, a college development committee has no statutory basis. It is not formed under any statute. It is done under some circular, which according to me does not pass the muster, my lord, of restricting public order. But that argument, kindly see, my lord, at page 14, paragraph 14, page 84. Apart from the fact that the circulars have no legal sanction behind them, in the sense that they are not issued under the authority of any statute, we also notice that the circulars do not oblige each and every pupil to join in the singles, even if he has any conscientious objection based on his religious faith. On the other hand, one of the circulars very rightly emphasized the importance of religious tolerance. It is said that all religions should be equally respected. If two circulars are to be interpreted as to compel each other and every people to join in the singing of national anthem despite his genuine conscientious religious objection, then such compulsion would contravene rights guaranteed by 19 and 25. Then, my lord, the question which fell from my lord Justice Dikshit, lord, as to what is law, etc., that, my lord, is answered over the page at page 85. I'll not trouble your lordships with that right now. And then, my lord, kindly turn to page 86 in the context of Article 25. Page 86, paragraph 19. The last 4 or 5 lines from the bottom of that paragraph. Therefore, when the fundamental right of freedom of conscience and to profess, practice and propagate religion is invoked, the act complained of as offending, kindly see this, my lord, the act complained of as offending the fundamental right must be examined to discover whether such act is to protect public order, morality and health, and whether it is to give effect to the other provisions of Part 3 of the Constitution, and or whether it is authorized by a law made to regulate or restrict any economic, financial, political or secular activity which may be associated with religious practice. This is the test which they formulate.
Please read further. Complete.
I'll read it, my lord. I'll read the whole thing, my lord.
Yes.
It is the duty and the function, I'm grateful now, it is the duty and the function of the court to do so. Here again.
No, before that you will skip the 6 words.
I'll read the whole thing, my lord.
So may be associated with the religious practice.
Yes, I'll read that, my lord.
Or to provide for social welfare and reform. These words.
Yes, I'll read it, I'll read it again, my lord. By a law made to regulate or restrict any economic, financial, political or secular activity which may be associated with religious practice, or to provide for social welfare and reform. I'm grateful, my lord, that a law providing for social welfare and reform definitely, my lord, is a restriction under Article 25(2) on the fundamental right. So the question will be, my lord, where is that law which provides for social welfare and reform on the basis of which, my lord, this headscarf today is said to be prohibited. And as far as 25(2) is concerned, my lord, the submission is that a college development committee has no statutory basis. I'll come to that, my lord. Now see, my lord, 25(2), what should be the approach of the court? Page 88, my lord. At this I commend, my lord, for my lord's consideration.
Can you articulate the ratio of Bijo Emmanuel?
Yes, my lord. Lord,
Yes.
after completing this, can I put it into 2 or 3 compartments? My lord, that's my concern.
Now you had read
Yes.
loudly read
Yes.
Bijo Emmanuel.
Yes, my lord.
So what is the ratio emerging from this?
The
And what
ratio,
is
my
the
lord,
restrictive
is not-
power of the state in the
Yes,
light of para 19?
Yes, my lord. My lord, in the light of paragraph 19 and other paragraphs, my lord, 2 things according to me flow out, my lord. One, that of course the state has the power to, my lord, regulate economic, financial, political or secular activity with a religious practice to provide for social welfare or reform. There's no doubt about it. At the same time, if there
Even
is
if
no
it is
such,
essential religious practice?
no, my
Our
lord.
question is,
Yes.
kindly appreciate.
Yes.
I am articulating the question for
Yes,
your
ma'am.
answer.
Yes, ma'am.
Essential religious practice should be the focal point of 25.
Yes, my lord.
Agree?
My lords, that is
25,
also
as
today.
the Honorable Chief Justice said,
Yes.
it begins with the word subject to.
Yes, my lord. Yes. True.
And class 2 you have also read.
Yes.
Class 2 is interpreted in para 19 at the rock bottom of the
Correct.
page 86, which you
That's
have
right,
read.
my lord. That's right, my lord.
It says, so you also of the view, that view only, whether that will be applicable to this case or not is another thing.
Correct, my
On
correct.
law, let us be clear first.
Yes, my lord. I completely subscribe to your
Essential
lordship.
religious, I am putting to you now, whether essential religious practice is absolute or is susceptible to regulation by the state by law. Whether
Lord,
there is law
I'll
or
answer that straight
another
away, my lord.
argument.
I'll answer that
What's
straight
your
away.
answer?
Yes, my lord. My answer is this.
Yes.
That as far as essential practice is concerned, my lord, that very doctrine connotes that it is not related to economic, financial, political, or secular activity which is associated with religion. Kindly see this, my lord. A
That is
religious,
not subject to Article 25(2).
my lord, that will come. Just, my lord, may I just explain the contours? Under Article 25(2), the state has been given the power to restrict any economic, financial, political, or secular activity associated with religious practice. Right, my lord? We have no difficulty on that.
Regulate or
Now, my lord,
reform.
yes, my lord. Now, this very concept means that other than core religious activity, other aspects can be regulated by the state. What are the other aspects? Finance, economic, political, secular activity. Now, as far as core religious practice is concerned, that comes from 25(1), not from 25(2). Even that core religious practice is not absolute. Your lordships are absolutely right. If that core religious practice offends public order, offends morality, kindly see 25(1), my lord.
Can it be read separately?
Yes, my lord, 25. That is how your lordships have interpreted.
25(1) and 25(2)
Yes.
can be read separately.
Yes, my lord. It has been so read by a series of decisions, my lord. 25(1) has been interpreted, my lord, to mean that even as far as core religious practice is concerned, if it offends, my lord, public order, morality and health, the state has the power to regulate. Even, my lord, aspects relating not to core religious practice, secular aspects, financial aspect, economic aspect, all these aspects can also be regulated by the state. That flows from 25(2). Lord, that's, Lord, I'm grateful for that question.
These economic, financial, political, or secular activities,
Yes.
which are associated with the religious practice.
Yes.
Correct, my lords, correct.
Not that they are separate.
I bow down, my lords. I bow down.
Associated with.
What is the
Associated
difference,
with
my lord? What
religious
is the-
practice,
Let
they
me
have
address
to
that point, my
can be
lord.
regulated.
Yes, my lord. I bow down. There is no difficulty, my lord. Now,
Yes.
what is the difference between 25(1) and 25(2) is what I was placing for my lord's consideration. 25(1) says, my lord, public order, morality, and health are the broad, my lord, restrictions which can be placed as far as the freedom of conscience and right to profess is concerned. This may concern, my lord, even a core religious practice. If it offends public, kindly see this, my lord. If it offends a public order or a health issue or a morality issue, the state has the power.
Now,
Now,
in this
under-
context,
Yeah.
in this context, you read the last portion of paragraph 19 of this.
Yes,
which
I'll read
was-
it. I'll read it, my lord.
It does not distinction between the
Yeah.
Article 25(1) or
Yes,
25(2).
yes, my lord. And in fact, my
Has to
lord,
be read.
I'll read 19, my lord, last 4 lines. That's
Yes.
very important, my lord.
Therefore,
Therefore, whenever the fundamental right of freedom of conscience and to profess, practice.
this is Article 25(1).
No, my lord, this is kindly see,
Freedom
my
of
lord.
conscience and to profess, practice, and propagate religion is invoked. This is part 1.
Yes.
The act complaint of offending the fundamental right must be examined to discover
Correct,
whether
correct,
such
correct,
act is to protect public order, morality, and health, whether
Lord,
it is to give back to
probably
the
to assist,
other provisions of,
probably
and
to
or
assist,
whether it is authorized by law made to regulate or restrict any economic, social, political, or
Correct.
secular activities. So they
Lord,
both have to be read together.
Lords, probably what I am saying, if I read paragraph 19 from the
What
beginning.
we just trying to
Yes, my lord, we are all students of law, my
Yes.
lord. We are all trying to
They
understand.
have other questions. We have other questions which the state has to answer is
answer.
another
This
thing.
is not
Yes,
that
yes.
that
Now you are
Lord,
our
we are all
focal
this
point.
constitutional law is
We are just
fascinating. Lord.
considering
We
the
get to
import
learn
of
from
the provision.
discussing this with your lordships. But just see beginning of paragraph 19, and probably that will assist your lordships in understanding the contours of Article 25. We see the right to freedom of conscience and freely to profess, practice, and propagate religion guaranteed by Article 25. Kindly see this, my lord. There are two. That's what I am saying. It's totally different. Is subject to 1, public order, morality, and health. 2, other provisions of Part 3, which is forms of part of Article 25(1). 3, kindly see this, which is Article 25(2). Any law regulating or restricting any economic, financial, political, or other secular activity which may be associated with religious practice. So, my lord, the court, Supreme Court has said that there are 3, my lord, restrictions. 1 is that the restriction of public order, morality, and health. 2nd is other provisions of Part 3. 3rd is 25(2), which your lordships put to me. Now, my lords may kindly see.
There is one more, or to provide for social welfare and reform.
Yes, my lord. Lord, that they have included in 3. Yes, my lord. That they have included in 3, my lord. Lordships will see the headings 1, 2, and 3. Lordships are absolutely right, my lord. In 3, they break it down into 2, A and B. Lordships have seen paragraph 19. I'm deeply obliged. My lord. Lords, what I was placing at page 88. When we are concerned with the Article 25 breach issue, what should be the approach of the court, my lord? Page 88. And they quote, my lord, a Bombay High Court judgment of Jamshedji with approval. If this is the belief of the Zoroastrian community, and it is proved undoubtedly to be the belief of the Zoroastrian community, a secular judge is bound to accept. My lord, Justice Dixit got it? Page 88, I'm sorry.
Yes, yes.
Yes. It is not for him to sit in judgment over that belief. He has no right to interfere with the conscience of a donor who makes a gift in favor of what he believes to be the advancement of his religion and the welfare of his community or mankind. We do endorse the view suggested by Davar J's observation that the question is not whether a particular religious belief or practice appeals to our reason or a sentiment, but whether the belief is genuinely and conscientiously held as a part of the profession or practice of religion. Our personal views and reactions are irrelevant. If the belief is genuinely and conscientiously held, it attracts the protection of Article 25, but subject, of course, to the inhibitions contained therein. So this is the approach, my lord, which I was commending. And therefore, my lord, what the Supreme Court ultimately said was that this expulsion of the students, that is at page 91, my lord, because they refrained from singing the national anthem, was totally illegal. We are satisfied in the present case that the expulsion of the 3 children from the school for the reason that because of their conscientiously held religious faith, they do not join the singing of the national anthem in the morning assembly, though they do stand up respectfully when the anthem is sung, is a violation of their fundamental right to freedom of conscience and freely to practice and propagate religion. My lords, just one more judgment on this Article 25 when we are here. That latest judgment of Shaira Banu, my lords, on this triple talaq thing, is a constitution bench, that is 2017, my lord. Page 1.
In this compilation,
it's not there in the compilation, my lord. I believe it was. It is handed over separately. My learned friends have that separate copies, my lord, of that judgment. If I can just place, my lord, 2 or 3 paragraphs in that. And I just want to place Justice Joseph's, my lord, concurring opinion. And Lordships will note the point which I am making, that the point is this, that if the Islamic scripture of Holy Quran, my lord, says that this is a practice which is obligatory, the courts are duty bound to, my lords, allow that practice for the purposes of Article 25. In that particular case, my lord, they said that this triple talaq concept is not there in the Quran itself. It is not sanctioned in the Quran, and therefore it was struck down on the anvil of Article 14. And that, my lord, I just want to show. Just have a look at, my lord, paragraph 7.
Mr. Kamath, another question to you.
Yes,
whether what all is stated in Quran is essential religious practice?
No, I'm not saying that, my lord. Lord, for the purposes of this case, my lord, that larger question will not arise.
Because
what arises today? Yes, my lord.
Quran is considered to be, Holy Quran is considered to be the first source of Islamic law by all text writers.
Correct, my lord.
And you have quoted the verses from Quran only.
Yes, my lord. Lord, I would not like to
answer the question. We want to know what all is stated in the Holy Quran. Is it to be treated as an inviolable injunction?
My lords, I would not like to, my lords, with respect, my lords, may I answer this question? I would not like to, my lords, comment on the larger issue of whether every tenet of, my lord, what is prescribed in the Quran is an essential practice, because that really doesn't arise for, my lord, consideration of your lordships. Your lordships have time and again, my lord, respected this tradition of, my lord's judicial review, that what doesn't arise for consideration, your lordships, my lord, will not get into that area. Today, my lords, we are concerned with a religious practice of wearing a headscarf. And my submission is that wearing a headscarf is an essential part of the Islamic faith, my lord. On the larger question, my lord, whether certain parts of Quran are essential or not, Islamic scholars say, my lord, that the Quran is the first source. And that's what the Supreme Court also has said. Islam can't be anti-Quran. That is what the Justice Kurian Joseph said. But I respectfully beseech your lordships not to enter into the larger, my lords, canvas, because that really doesn't arise for consideration. Please have a look at paragraph 7 in that light, my lord. Paragraph 7, my lord. And it is, the judgment proceeds on the basis, my lord, that what is stated in the Quran is inviolable. This is the basis, my lord, of this judgment. Just have a look at, my lords, paragraph 7. There may be interpretations, but just have a look at paragraph 7. There are 4 sources of Islamic law. Quran. My lord, Justice Dixit got it, my lord?
Yes.
There are 4 sources of Islamic law. Number 1, Quran, Hadith, Ijma, and Qiyas. The learned author has rightly said that the Holy Quran is the first source of law, what your lordships put to me. According to the learned author, preeminence is to be given to the Quran. That means sources other than Holy Quran are only to supplement what is given in it and to supply what is not provided for. In other words, there cannot be any hadith, ijma, or qiyas against what is expressly stated in the Quran. Islam cannot be anti-Quran. I rest my case with that. According to Badr Ahmad in so-and-so case, then my lord, turn to paragraph 8. It is in this background that I make an attempt to see what the Quran states on talaq. There is reference to talaq in 3 surahs. In surah so-and-so, so-and-so. They check the, my lord, they discuss the various surahs as far as triple talaq is concerned. And then, my lords, paragraph number 12. These instructive verses do not require any interpretative exercise. Paragraph 12, my lord. They are clear and ambiguous as far as talaq is concerned. The Holy Quran has attributed sanctity and permanence to matrimony. However, in extreme unavoidable situations, talaq is permissible. But an attempt for reconciliation, and if it succeeds, then revocation are the Quranic essential steps before talaq attains finality. In triple talaq, the door is closed. Hence, triple talaq is against the basic tenets of the Holy Quran, and therefore it violates Sharia. And then eventually, my lord, paragraph 27, and that's the last judgment which I want to. That's the summing up of the law, my lord. What they say, what is bad in Quran cannot be good in Shariat. Para 27, my lord. So therefore, kindly, I'll just place that, my lord. Fortunately, this court has done its part in Shamim Ara. I express and endorse and reiterate the law declared in Shamim Ara. What is held to be bad in the, I'm sorry, my lords. My lord, the Chief Justice got para 27, my lord. Para 27, my lord. Page 53 of the report. Placitum G. Fortunately, this court has done its part in Shamim Ara. I expressly endorse and reiterate the law declared in Shamim Ara. What is held to be bad in the Holy Quran cannot be good in Shariat. And in that sense, what is bad in theology is bad in law as well. So, my lord, the submission was this, that since the Quran, my lord, itself says so, as far as these headscarves are concerned, we need not go to any other authority, my lord, and this would be protected under Article 25. My lords, the last submission which I want to make on the last submission which I want to make, my lord, is that even I did not go as far deep into essential religious practice at all. Because, my lord, that essential religious practice theory comes in When, my lords, a practice of fundamental right of religion violates somebody else's right, or, my lord, that act itself complained of is so abhorrent, is so, my lords, despicable, that concepts of public order, morality, and health will override those considerations. That issue doesn't arise really here. People are only wanting to wear their headscarf, which is a facet of their freedom of conscience. And even keeping aside, my lord, this larger question of whether, my lord, it's an essential religious practice or not, I am respectfully submitting, my lord, that state is duty bound to ensure that freedom of conscience. Now, my lords, coming to this GO on the second part. Now, my lords, the GO, my lord, lordships have seen, refers to a GO of 31st of January 2014. The first part I have completed, my lord, that the declaration made in the GO that this wearing a headscarf is not protected by Article 25 is absolutely illegal. And I have made that good not only by judgments of the High Court, but of the Supreme Court in Vijay Emmanuel and also Shaira Banu. But now I'm saying that even keeping that aside for a moment, this whole delegation to the College Development Committee to decide whether to permit wearing of a headscarf or not is a total abdication of state responsibility. Just have a look at, my lord, the circular again. And I dare say, my lord, that the person who has drafted this GO has not bothered to look at Article 25. Just have a look at, my lord, the circular first. The first page of the circular. Government circular dated 31st January 2014. It refers to a government circular of 31st January 2014. If I can request my learned friends to hand over that government circular, please. This is referred to in this GO of 5th of February. Shahul, if you can just hand it over to the Honorable Court, please. Lords, I'll read till that dig it out, my lord. I'll just read. This is a circular, my lord, which has been issued on 31st January 2014. And it says, Education Department is providing first and second PUC education.
The English translation of the GO of 5th February.
February. Yes, my lord.
It's not it.
It's not correct, right?
Anyway, we have.
Yeah.
I don't. It's
Yes.
incorrect.
I follow. Yes, my lord.
Words are.
It's not entirely correct.
Is,
I bow down, my lord. Yes. I bow down, my lord. I bow down. Lordships will just see the circular, my lord. This translation, the Kannada version is also there in the earlier page. The English version, my lord, Lordships will see. Education Department is providing first and second PUC education in the state. PUC education is the main stage in the student's life in accordance with the government and department direction and in order to utilize the grants as well as in maintaining academic standards and development of infrastructure. We are hereby directed to form. I think it should be you are hereby directed to form a college development committee and to follow the guidelines. So president is MLA. Well, I'm sorry, it's a very bad translation. It says respective constitution must be probably respected. Constituency probably. Then vice president, local representative nominated by the MLA. 4 persons from students' parents. Among them, 1 parent should be female, 1 parent SC, ST. Person who is interested in the education field. 2 members from the students' representative. Vice principal, senior lecturer of the college. 4, principal of the respected PU college. Now, my lords, the impugned GO says that this college development is, I'll call it the MLA committee, my lord. This MLA committee will today decide whether headscarf is to be worn or not. That's the long and short of it, my lord. So the constitution says fundamental freedom of conscience is subject to public order. And today the state says what is public order will be decided by an MLA committee. The submission is this, my lord. Public order is an essential executive function. Can't be left, my lord, to an MLA committee.
Are not MLAs aware of constitutional provisions?
Yes, my lord, obviously.
They will do according to that.
No, my lords, my submission is this. This is an extra legal committee. Kindly see this, my lord. There is no sanction in law because this public order, my lord, because please see the repercussions of this. Fundamental freedom of conscience has been made subject to public order. So an extra legal committee outside the paradigm of the statute will decide whether wearing a headscarf in a particular area violates public order or not. I respectfully submit, my lord, this is making a mockery of the right to fundamental freedom. I can understand, my lord, the state doing it, but the state, my lord, permitting a committee, my lord, to take a call on such an important facet of fundamental freedom, and that I respectfully submit, my lord, is totally illegal.
It does not say
now, my lords,
it does not say about the headscarf. It says about the
yes,
uniform.
Yes, my lord. I am
And
saying
that the Act provides. That the Act provides.
No
Why you
problem,
want
Lord.
to
Nobody.
exclude the legislators? I do not know.
No, Lord, I am not saying that. The legislators' opinions can be taken by the state. No difficulty, my lord. But can they be the sole repository of exercising that power to restrict freedom, which is the domain of the state?
Please,
no, Lord, just see.
Kindly read.
Yes,
kindly do not assume so many things, I tell you.
Yes,
With great respect.
Yes, my lord.
Committee,
Yes,
X, Y, Z shall be the members of that. Where is the veto given to the MLAs?
No, my lord, I am not saying that. What I am saying, the submission is this. I have probably not been able to make myself clear. The submission is this. Freedom enshrined in the Constitution is subject to public order. Public order is a state executive responsibility. Whether that particular practice violates public order or not has to be, my lord, understood and prescribed by the state and state actors. And state actors.
To be decided by the committee. This government order only talks about the uniform to be prescribed by the college development committee. It does not say that the public order or all that is to be
the submission is this, my lord. In the first part, which your lordships have seen, the state says that, look here, there is no fundamental right as far as wearing a headscarf is concerned. Then tells the development committees that you can do what you choose. I am saying that what you can do, what you cannot do, cannot include, my lord, a direction, so to say, that headscarf will not be permitted, because that would amount to saying that I am putting a restriction on the ground of public order. Well, that's on the second part. Now, my lords, may kindly just see just a few, 2-3 more aspects of this case, my lord. One is that one argument can be that wearing a headscarf, my lord, leads to a problem because some other students want to display their religious identity. The courts, my lord, have, and your lordship's court, Supreme Court, my lord, have been faced with this problem. And the answer has also been, my lord, elucidated by the Supreme Court, saying that the state should make a conducive atmosphere for exercise of those fundamental rights. And that is the next line of cases, my lord, which I want to cite. Just have a look at, my lord, 2001 1 SCC page 582, that in volume 2 of the compilation, your lordships will find there is a volume 2, my lord, of the compilation.
Is it about validity of the committee? Whether are you still arguing about the validity of the committee?
No, my lord, I'm finished with that, my lord. I am finished with the GO. I am finished. I have tackled, my lords, Article 25. I have tackled, my lords, the second aspect also. Now I am saying, my lord, how, my lord, this freedoms 25, 19, my lords, have to be, my lord, seen by the state, because the defense is, look here, it's going to create a law and order issue, therefore we will not permit. That's the long and short of the state's defense. Whether that can be the basis, my lord, for curtailing fundamental freedoms, this matter has come to the Supreme Court not once, at least 3 or 4 times, which I'll show, and how the courts have dealt with it. Just have a look at, my lord.
Sorry, one second.
I'm sorry, I'm sorry.
Yes. Can you give one judgment of any of 25 high courts in the country or of the apex court, which says the popular leader, the representatives of the people, cannot be part of any committee like this, nearby, not exactly the ratio, which suggests this?
No, my lords, I am not, my lord, they are public representatives. I am not saying, my lord, that they don't have a part in public administration. I am not saying that. What I am saying is that public order is a police function. It is a function, my lord, which has to be carried out by functionaries of the state, obligated to maintain public order.
So you do not have any decision in support of the proposition which I said?
Yes, my lord.
No decision as such?
No, my lords, I have not. I was looking at it, my lord. But I'll, if I get something, my lord, I will make that good, my lord.
All right.
My lords, may kindly see this 2001 1 SEC page 582, which is there at page 76 of this compilation. Not just one line. This is the context of that film. Just one line, my lord. And I'll get on. Para 8. Once an expert body has considered the impact of the film on the public and has cleared the film, it is no excuse to say that there may be a law and order situation. It is for the state government concerned to see that law and order is maintained. That's number one, my lord. Second judgment in the same vein is, my lord, at page 81, and this is a little interesting. Starts at page 81, my lord. This is 1982, 1 SCC page 71.
There is no dispute to this that the responsibility to maintain the public order, law and order, is the responsibility of the state.
Yes. No, my lords, what I was saying is that when a question comes that my religious freedom or any freedom guaranteed in the constitution is being violated, can the state, my lords, just take up this facile plea? And that's the word used in the Supreme Court judgment of Abbas Ali, that look here, this will create public order issue, and therefore we will restrict that freedom. Now, in that context, I'm saying, just have a look at, my lord, page 123.
It has not said so.
My lords, the entire basis of the GO is that there has to be uniformity. People should not display their religious identity because it is fomenting trouble. And therefore, we are of the view that wearing a headscarf is not essential. And therefore, we tell the CDCs to take a call. Now, my lords, just have a look at page 123, para 33.
No, not like that.
Yes.
We'll be very happy to go through all the judgments is one thing.
Yes.
But question is what Honorable Chief Justice is saying is,
yes,
how that is relevant to this case?
My lord, this will be, in my respectful submission, completely, my lords, covered for the simple reason that today, my lord, what is it that stops, my lord, the state? What is it that stops the state from permitting me to exercise religious freedom? What is it that stops the state? I ask myself. They say, my lords, public order. There will be disturbance. To students from two communities, there will be a problem. They say this, my lord. And that is why I submit.
You are presuming it.
No, my lords, kindly see what is the defense. Well, if they say there is no public order issue, I am happy, my lords. If that is the stand,
we have not heard them.
Just, my lords, I am arguing, my lords.
Till now.
I am arguing on arguendo. Lords, if they say that there is no public order issue, then I am safe, my lord. 25(1), there can't be any restriction. The circular and the GO has to go. They can restrict it only on the ground of public order as far as 25(1) is concerned.
We cannot presume what they will say.
I am just saying, Lord, I'll get a chance on rejoinder, but I am saying that as far as public order is concerned, if the stand of the state is that this has nothing to do with public order, let them come and say, I have no problem. Then there can't be any restriction. There can't be any restriction under 25(1). That's the submission, my lord. Now, just have a look at page 123, para 33. I would be happy if the state says that, my lord, as far as my case is concerned.
On what proposition you want to show?
Yes, my lord. Kindly see, my lord, just have a look at that when there are rights which are crystallized, and in this case, my lord, in my case, the right to wear a headscarf, the state cannot say, my lord, that wearing this will incite passions, will incite problems, will incite violence, and therefore restrict that right. That's the point which I'm making, my lord. Just have a look at, my lord. Yes.
Is it their stand?
Where is the stand?
My lord,
we want to appreciate.
My lord, I am saying.
First, let their stand be clear. Then only we can appreciate your argument.
I bow down, my lord. I bow down. The submission is this, my lord. If they say that there is no ground made out, everything is fine, that there is no public order issue, then, my lords, this GO has to go.
We can understand that you say that it is an essential religious practice.
Yes.
And therefore it is protected under Article 25(1). All this we can appreciate.
Yes.
But we cannot appreciate this argument that the state is saying that since it involves public order and all that, the state is not yet said anything before us.
No, lords, what I am saying is I'm slightly putting it in a different manner. I am saying, my lord, that the state is obligated to create a positive environment for exercise of fundamental freedoms, and which the state is not doing, my lord, by way of this GO. And lordships put to me, where is the state saying that you can impose a restriction on that they are imposing a restriction on public order? In fact, if your lordship sees the GO, they say public order, my lord. Kindly have a look at that GO. That's a very important question which fell from my lords. Lordships asked me a very pertinent question. How do you assume that it is public order? One of the grounds which they take is public order. Just have a look at the last part of the GO, my lord. That operative portion, as they say. In colleges that come under the pre-university education department's jurisdiction, the uniforms mandated by the college development committee or the board of management should be worn. In the event management does mandate a uniform, students should wear clothes that are in the interest of unity, equality, and public order. Public order, they say that, my lord, the ground which is taken.
I did not want to. The translation was, in fact, I wanted to.
Where is that? Kannada.
In fact,
contrary. I'm not.
Do you have the official translation of this?
Possible, sir. In fact, now I have got it done from Directorate of Translation.
Give it.
We have given. Of course, possible words my friend. Somebody local would have translated that mistake. Now this is the official one which we have done. Runs contrary to what the original is.
We also feel that the translation is not correct.
Yes, my lord. It may not be up to the mark, my lord. I concede, my lord. I
It
concede.
is possible that one of my errors.
Yes, sir.
Can be blamed for this.
Yes, yes.
But it runs contrary to the original document.
Just your official translator, does he know Kannada?
Today words unlike earlier days. It's slightly difficult. We have a translation department. What is that? This is 5-2.
My lord, sir, the Kannada word which is used,
I just want to
Sarvajanika Suvyavasthe. So, my lord, what I was submitting is, just have a look at.
1 second, we will verify the official version of the state first. In fact, there is an official Languages Act which mandates every legislation. Yes, it has to be in the local language.
This of course, Lordship now kindly discuss Kannada version. Kindly see Kannada version and then compare it.
Sarvajanika Suvyavasthege.
Yes.
Suvyavasthe is not order.
Public order.
It is not order. Problem is,
Provide good provision. Marathi. Suvyavastha.
Suvyavastha is Hindi also and Marathi also.
ಕಾಲೇಜು ಅಭಿವೃದ್ಧಿ ಸಮಿತಿ ಅಥವಾ ಆಡಳಿತ ಮಂಡಳಿಯ ಮೇಲ್ವಿಚಾರಣಾ ಸಮಿತಿಯು ನಿರ್ಧರಿಸುವಂತಹ ನೆಕ್ಸ್ಟ್ ಸೆಂಟೆನ್ಸ್ ಇಸ್ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್. ಆಡಳಿತ ಮಂಡಳಿಗಳು ಸಮವಸ್ತ್ರಗಳನ್ನು ನಿಗದಿಪಡಿಸದೇ ಇದ್ದಲ್ಲಿ ಸಮಾನತೆ ಮತ್ತು ಐಕ್ಯತೆಯನ್ನು ಕಾಪಾಡಿಕೊಂಡು ಹಾಗೂ ಸಾರ್ವಜನಿಕ ಸುವ್ಯವಸ್ಥೆಗೆ ಭಂಗವರದಂತೆ ಇರುವ ಉಡುಪುಗಳನ್ನು ಧರಿಸಿಕೊಳ್ಳುವುದನ್ನು ಆದೇಶಿಸಿದೆ. So kindly see translation is common. It says in the event of the management not fixing the uniform, if you adopt to a uniform which should maintain unity and of course equality among the
It are in the interest of unity.
the translation which has been given last sentence. In the event the management does mandate a uniform, etc. In fact,
it is translated in Delhi, not in Bangalore. Don't worry about it.
in this manner, we lead to a conclusion that notwithstanding, even assuming the management is to give a uniform, yet there could be a different one. And the last word that it is not public order. Almost was the context where it is not public. So the translation is incorrect. But it could be a bona fide mistake.
But sir, if I can resume, my lords. My lords, one of the grounds which is taken is Sarvajanika. Sarvajanika is public, my lord. Suvyavasthe. My lords, Vyavasthe can be order, a good order.
No.
Yes.
I'm sorry.
Good.
An order like this cannot be interpreted like a statute.
I bowed on, my lords. I bowed on, my lords.
Order, you have to see these orders. There are good books on Ego Kannada by G. Venkata Subbaya. Perhaps you have not seen it.
Yes, my lord.
He says how translation should be read.
Yes, my lord.
You can't read the government orders, circulars, like statutes of Westminster.
Correct, my lord.
Only with common sense you have to interpret them.
Correct, my lord. Correct.
These words, as Justice Holmes used to say of the US Supreme Court,
Yes.
they do not have static meaning.
Correct, my lord.
They are the skin of living thought,
Yes, my lord.
and their content varies depending upon the words with which they keep company.
Yes, my lord.
Therefore, that way you cannot.
I bowed on, my lord. My lord, there is no difficulty at all. What I am saying is, one of the consideration is definitely public order in the GO. One of the, according to me, my lords, a plain reading. My lord, otherwise, if the state says, my lord, that it has nothing to do with public order, this GO for a moment cannot stand judicial scrutiny at all. That's my respectful submission, my lord. In the alternative, I am submitting.
In entry 1 of list 2.
Yes,
This much
Manoj. Yes, Manoj.
it
What
is
I am
not
submitting is this.
as it is understood
Yes, Manoj.
by Apex, as it is interpreted by the Apex Court in 3 judgments. One of them you cited.
Yes, Manoj.
Justice Nariman's judgment.
Yes, Manoj.
That it is does not relate to entry 1 in list 2.
Correct, Manoj. Correct.
Then you can proceed.
So therefore, my lord, looked at from either angle, if they say it is not a matter of public order, it is not protected by, my lords, 25(1), the exemption of 25(1) goes. So therefore, my lord, this GO has to go in any event. And I am not only challenging the GO, I am also asking a positive mandamus from your lordship to permit me, my lord, to wear a headscarf when I'm going to school with the same color. I am not asking for any distinction as far as uniform is concerned. So that, my lord, a positive mandate also I'm asking from your lordships. And that, my lord, positive mandamus is mandated, my lord, by a series of decisions.
These words. That's what.
Would your lordships like me to continue tomorrow, my lords, or subject to your lordship's pleasure, my lord? I am here, my lord, host, whenever you lord. We have troubled your lordships enough today. Lords, I have about 15-20 minutes more, my lord, of submissions to make. I can finish today if your lordships permit me.
Who else want to argue on behalf of the petitioners? Because accordingly we will...
Shall I make a very short request, Lord? Your Lordship Justice Daikhain, Lord, in the first innings, was pleased to permit us, Lord, to supply certain materials, and we are ready with certain materials also. His Lordship was generous enough to hear me.
We will not stop anyone from arguing. Whoever wants may argue.
Yes, all that I am submitting. All that I am submitting on 2 conditions. One, we won't be repeating anything which the petitioners have been submitting. No repetition, nothing in the nature of repetition. Number 2, but there are certain additional materials which my counterpart advocate Rajita is there, and I will be submitting in support of the petitioners. What I thought requesting your lordship was to make some space before the respondents argue, and we won't be repeating any submission which has already been advanced.
All right, Mr. Kalvarishwaram.
Lord, if your lordships give me about 10 minutes today, I will try to wrap up, my lord. If your lord subject to lordship's pleasure, my lord. I'll wrap up today itself, my lord.
This may be rather before the respondents start. That's all.
I, my lord, just mention, my lord, I'm appearing in the writ petition that at the 4th place at number 4, my lord, on your lordship's board.
Yes.
And I'm for the petitioners, my lord. And I will also like to address your lordships, my lord, subject to your lordship indulgence.
All right, all right.
And without repeating any of the arguments which are made by my learned friend, Mr. Kamath, my lord.
Yes.
All right, all right.
And my lord, shall I place the completion before lordship today, my lord, or can it be done when at the time when it is taken up?
So Kaleshwaram, they'll give you time, don't worry. My lords, may I, would you subject your lordship's pleasure, my lord? I'll try to wind up today, my lord, subject to.
The court is muted. We are unable to hear the court. The court is muted.
Lord,
we are unable to hear the court.
Unmute.
Yes.
You have moved some application for impleadment.
Yes, I have moved. I have moved that application.
Just a minute, Mr. Kumar.
Please.
Yes.
I made 2 applications.
For what?
Application number 1 is for clarification on the interim order based on court was pleased to make the last date of hearing. In our case, relief we have not. But we have read that yes, whatever uniform is prescribed, we follow that.
Your one application is for clarification. Other?
The other application is if it is permissible. We have seen that the proceedings of this court have been highlighted in various media, especially social media, and they work in the election states. So if this honorable court could consider whether proper to put out the hearing of this case till the last phase of election is voting is over. The matter need not wait till the election results, but once the polling is over, the matter can be heard on the very day.
We have nothing to do with the voting.
It's an appeal to the court because this is an occasion when the Supreme Court should rise to the occasion and take the challenge that is posed by.
You see, we every day we have been making a request to media and social media to be more
I
responsible.
think they were right. In fact, I'm grateful to the court.
We cannot do that, Chief.
And
Mistakes of somebody. Election Commission comes, we can.
If this request is made from the election commission or some authorities who are holding the election, then we can consider it. But otherwise, how can we consider this request?
Social media is something either the election commission or the other authorities are able to exercise.
Under Article 324, we have seen, sir, such causes are taken by Election Commission of India. You are not the voter in other states. Perhaps none of these people are the voters. Oh.
But the issue is a live issue.
Nobody comes from that state also, saying that our elections are being affected by your proceedings, therefore do not. Nobody's case it is.
If you people agree, we can put off this live streaming. That we can do it. That is in our hand. That we can put off live streaming. That is no problem. But so far as making any restriction on the media, that is not.
No, my lord.
Decides, we'll avoid it.
Well,
Also, as far as
your application
For a long time or other, for the first time.
We wanted the responsible advocate.
We'll at the appropriate time we will consider it when we'll hear you. Then we will consider your application. But you are for the petitioner, one of the petitioners.
Yes,
All right. All right. Anybody else for?
I am also in support of the petitioners, my lord. I've filed a intervention application in petition number 2347 of 22.
With Kaleshwaram Raj.
That is
Separate application.
That's a separate application, my lord.
Just a minute. Yes, you want to argue on behalf of the petitioner?
Yes, my lord. In support of the petitioners, my lord. If I may make one submission, my lord, I do not want to jump the queue, but I wish to make the submission because the tone and the...
We are not considering any submission.
Yes,
we are just putting down the names of the advocates who want to appear on behalf of the petitioners.
Yes.
That is all.
My name is Advocate Tulasi K. Raj, my lord. That may be noted.
Yes. Yes.
And myself, if your lordship pleases, my lord. Not I appear for the petitioner in writ petition number 3038.
We have noted your name, Mr. Yusuf Mustafa.
No, thank you very much. I'm much obliged.
And myself, Rahmatullah Kotwal, Milord, I have filed an impeding application in the petition number 1, Milord. Well, I'm supporting the petitioners, Milord.
13% for the petitioner, my lord. My name may be please. My lord, supporting the petition. And 14%, my lord. Supporting the petition. My name may be kindly noted.
You are for the petitioners? Respondent we are not considering right now. All right. Third. All right. We are first thinking of how much time we have to give to the petitioners. Only therefore we were noting the names of the petitioners. We will have this matter again
My
tomorrow
lord,
at 13.
I am the party.
I need 5 to 10 minutes to wrap up, my lord.
We
For
heard
petition.
the arguments of Mr. Devdutt Kamath on behalf of the petitioner and his petition so and so. Are continuing. It is informed at the bar that Mr. Kalmaneshwar, Senior Advocate, Mr. Yusuf Machala, Senior Advocate, Mr. Ravi Verma Kumar, Senior Advocate, Tulsi K. Raj, and
Rahmatullah Kotwal, my lord.
Aditya Sondhi, who has moved an application for intervention IA 8 of 2022, are to be heard on behalf of the petitioners.
My lord, may I'm so sorry.
List on 15
Lords,
at 2:30 p.m.
My lord, may I most humbly submit, my lord, the first petition, my lords, the 6 petitioners had filed petition number 2146 of 22, my lord. My lords, I'll be appearing for the petitioners tomorrow, my lord. I seek your lordship's leave, my lord.
What is your name?
My name is Tanveer Ahmed Mir, my lord.
Note the name.
So Tanveer Ahmed, full name, sir?
My name is Tanveer Ahmed Mir, my lord. My last name is Mir, M-I-R. My lords, these petitioners, my lords, are the first petitions, my lords, in the line of order that were filed initially, my lord.
My name may kindly be corrected in the order, my lord. There is a mistake which probably that may not create a problem tomorrow.
Yes,
Kalishwaram Raj, my lord. I am, your lordship noted the name, it is Kalishwaram Raj.
Okay.
Obliged.
Public interest litigation has been covered with this matter, apart from the last matter.
With public interest litigation, you connect with